100. Even if the court thought the test was satisfied, the court should decline to make the order on discretionary grounds, given the role of the CTO and the Commonwealth recognizance that will both run to control any risk presented by the defendant. Section 25(3), mandatory factors to consider. 101. Division 2.4 of the Act sets out the requirements for determination of an application for an ESO. Section 25I provides that the court can determine an application by making the order or dismissing the application. Section 25I provides that the court can determine an application by making the order or dismissing the application. 102. Critically, Section 25(2) provides that in determining whether or not to make an ESO, the safety of the community must be the paramount consideration of the Supreme Court. Section 103. Section 25(3) sets out the matters to which the court must have regard. At this preliminary hearing stage, some of the parameters have not yet been the subject of evidence. For example, there are no reports from persons appointed by the court to conduct psychiatric or psychological examinations of the offender. And most unfortunately, the risk assessment report by Ms. Prince, prepared late June 2021, did not include any interface at all with the defendant, so revelation of his current stated thoughts and plans are limited to the 22 June 2021 review by Dr. White set out in 48 of this judgment. 104. To the extent that there is material available addressing these mandatory matters, I will refer to it at the level of detail I consider critical to my determination of this application. Given the very short turnaround time required of this judgment, not every aspect of all the 1,500 plus pages of material tendered can be the subject of reference or comment. Section 25(3)(b). Assessments of psychiatrists, psychologists, or medical practitioners as to the likelihood of the offender committing a serious terrorism offence and his cooperation with assessment. 105. Whilst it is clear that the court must take the evidence relied upon by the plaintiff at its highest, the report of Miss Prince is heavily qualified. On more than 10 occasions within the report, she makes reference to the fact that she had not had an opportunity to engage with the defendant, and so in a number of respects she declines to express a view about aspects of the potential risk that he presents. 106. The reason why the defendant was not made available to her to interview remains unexplained, despite my invitation to Mr. Emmett to explain why the defendant was not interviewed for the report. 107. From the conclusions expressed in the, quote, executive summary, end quote, it is evident that Miss Prince based her assessment on a file review only, but rather than simply allowing that fact to speak for itself, Miss Prince goes on to say that her report, open quote, should be considered an interim assessment only. Mr. K should be engaged in interview, underlined, to allow for a more informed assessment of his current vulnerability, risk profile, and protective factors, end underline, end quote, emphasis added. This is the justice adding emphasis to the amount of action that has been stacked up against the defendant and the fact that it is spurious and very uncalculated and far too numerous to address. 108. Miss Prince concluded, quote, Mr. K is currently assessed as moderate to high risk for politically motivated violence, violent extremism, or terrorist activities using the VERA 2R. His role would likely be one of a promotion, recruitment, and development of materials which promote the cause. When he would directly or indirectly promote the use of violence to achieve his goals is unclear. However, the emotive language and rhetoric is a genuine possibility to be interpreted as a call to arms. Mr. K's risk of grievance-fueled or targeted violence was assessed with the TRAP 18. This assessment suggests that monitoring and active case management is warranted. This would be best achieved through the application of an ESO with the joint management by the New South Wales High Risk Terrorism Offenders Team and the Community Corrections Terrorism High Risk Offenders. Details of recommended intervention and management strategies are outlined at the end of this report. Now, what should alarm most viewers is the word VERA, the Violent Extremism or Terrorism Activities Mental Health Assessment Tool. And this then goes again for TRAP, T-R-A-P. The targeted violence was assessed with TRAP 18. So these are two tools that they try and box you in with. This is, are you a left or a right? Well, I'm a left. Okay, well, we'll box you in that way then. Are you a Z or a B? Well, I'll box you further in that way then. That's what they've done. And it's very evident by the evidence that's been put on the court record by Justice Julia Lonergan.